Welcome to the Protiviti Legal Perspectives podcast series, where we feature corporate and law firm senior executives to discuss legal trends and business innovations that are driving legal department operations and the business of law. We're pleased to present a special edition of the Protiviti Legal Perspectives podcast series, which focuses on government contractors and federal cybersecurity rules and regulations. My Protiviti colleague, Perry Keating, Managing Director and President of Protiviti Government Services, interviews Alexander W. Major, law firm partner and co-chair of the Government Contracts and Global Trade Practice Group at McCarter and English. Alexander focuses his practice on federal procurement, cybersecurity liability and risk management, and litigation. We hope you enjoy the program.
Alex, welcome to the program. Excited for you to be here.
Thank you very much for having me. I appreciate the opportunity.
So, wow, if we thought 2023 was a year of new government regulations, sort of the end of 2023 and the beginning of 2024, looks like we're going to set some records here. So, leave it to the U.S. government on the day after Christmas, December 26th, to drop the new CMMC regulation that came out. And so interested in your thoughts of, what out of all of that material sort of gets our attention, makes us think about things we need to do different going into the new year.
Yeah, I think it's interesting because we've all known CMMC is coming. It's been out there in different forms, the iterations and the hints and allegations of it all. So, it's good to see that it's finally arrived. Or at least we know what it's going to look like when it comes in. It's still, I feel, in movie terms, it's still the cowboy and the horse far away, where we can't see all the details, but we know what's coming. And I think what we're going to be seeing, especially in 2024, is that rule. I know what you're going to say. We're going to see that rule getting rounded out. We're going to start seeing pieces of it fleshed out. We're going to start seeing exactly how it's going to operate. There are a lot of open issues and questions within that CMMC proposed rule, a lot of processes that I think a lot of people are interested in. I was looking today, and I think there might be over 180 comments so far, and there's still a couple of days until the comments close out. So it'll be very interesting to see how those comments all gel into that final rule, and to see how exactly DoD is going to finally bring this together. But I think they've definitely set the stage.
Right. So probably the number one question I get asked all the time is okay, when do I have to care about this? Like, is this a 2024 problem, a 2025 problem, 2026 problem? Right. They're like, so when's it going to hit me?
I think, yeah. And I know you and I've talked about this before. I think it's a 2018 problem.
Right. So, when it first came out. Sure. Of course.
Yeah. So I think, when people are looking at it, the contract clauses have been in federal DoD contracts for quite some time. So if you are meeting your requirements, and we know all contractors are meeting their requirements, then, it's just simply a position of being able to fit it. But, I think with CMMC proper, and I'm focused primarily maybe on the level 1 and level 2A portions of CMMC. When I say this, it really is just a matter of pulling your materials together, getting your ducks in a row, recognizing what's in your contract, whether it be FAR 52204-21, making sure you're meeting that at a bare minimum. And then if you're a defense contractor and you have covered defense information or CUI generally, we'll just say, then making sure you're meeting 7012, or at least on the road to meet 7012. If you're able to do that at some time, hopefully you already are. But if you're able to do that sometime this year, I think you're going to be in a good position to receive the CMMC ball when it's finally passed to you as a contractor. But I don't think we're going to see anything. I just be guessing. I have no idea when this is going to actually drop. Blessed and
yeah, right. So, certainly the CMMC was the one that came out, but, there's a lot of other regulations that have some impact on, those of us who certainly play in the government space. So there's been sort of this hanging FAR clause that was supposed to be the mirror to 7012 that said, hey, not only does DoD have CUI, but federal agencies have CUI, and you need to be able to be prepared for that. As that starts to come to fruition, any thoughts on what that means? Does that just mean, okay, I got to do it for all my contracts, or where do you see that headed?
Yeah, it's interesting. Like you, I teach on this all the time. And what used to be maybe an hour or maybe even a half day program now has grown so dramatically because of all the regulations. But, with the FAR cases out there that are 2021-17, the cyber threat, the incident reporting and information sharing proposed rule, there's a lot of new requirements that many companies, many enterprises are required now to be prepared to address. And what's weird, especially right now, is that a lot of this information is still sort of nebulous. It's still a little fluffy. So I really do think it's a situation where contractors of any sort, whether you're working for the Department of Defense, whether you're working for the Bureau of Land Management, need to at least start and understand data governance, right? They need to understand what they actually have. They probably already know if they have personal identifiable information, PII, personal healthcare information, which is great. You should really know if you have that stuff. But if you're working with the federal government, I think it really behooves any organization to recognize what do we have, because you probably absolutely have federal contract information or FCI. Now the question is, do you have CUI? And if so, what kind do you have? That is a bottom line, almost requirement for every federal contractor, civilian or defense. It's just a sense of data governance. What do you have? What are you getting? What should you expect to get?
Those are sort of overarching. It seems to me that some agencies have their own acquisition regulation supplement. And we're starting, it used to be 72 hours, right? You had 72 hours to figure out what happened, be able to report it, dutifully report it in. And I think we're starting to see, the Homeland Security acquisition regulation, I think the VA, they're starting to move to things like you've got 8 hours to respond, or you got 1 hour to respond. As somebody who's had to report incidents or work with people who've had to report incidents, wow, 1 hour, 8 hours seems pretty quick. Any thoughts on that?
Yeah, I think it all makes sense to a degree, right? And especially with the Department of Homeland Security side. I mean, the DHS is such a diverse entity, a diverse agency, right? I mean, it does everything from disaster recovery to law enforcement. So, and healthcare stuff, right? So there's elements to it that does make sense. What's interesting, so when we're talking about cybersecurity, so often we can break it down into the safeguarding element, which we were talking about, and then into the reporting element. So I think what DHS is doing with their rule, recognizing that, certain information, specifically PII, has to be, disclosed, a breach of PII has to be disclosed within an hour, all other incidents within 8 hours. I think the question is going to become, what exactly are you reporting? Like, right, within an hour, stuff went sideways, call you back later, right? I think that's going to be the challenge. Same thing with within 8 hours. What I appreciate about, in contrast to the DFARS, so under 7012, you have 72 hours to report. And I think one of the reasons 72 hours makes sense of it, we do a lot of these for clients, is because there's a lot of information that you probably should have readily available, but if something is happening to your system, if you lock out or whatever, you need to put together for the defense, the DIVNet, things such as contract number, contract personnel, phone numbers, program managers, et cetera. So that 72 hours allows a defense contractor the opportunity to provide that information. With DHS and specifically in some elements of GSA and some elements of VA, you might not have that information or necessarily need to give that information, but you can still give them hey, we're examining something's going on. But it's just whenever you're giving, and Perry, whenever you're giving information or whenever you're having to report this, you can only report what you know. And that's really hard, I think, for a lot of companies to do, because there's sometimes they want to guess, or they want to do conjecture, or they want to think, oh, it's limited. And in 1 hour or in 8 hours, you do not know. You don't know. So that's the one thing I think with anybody dealing with these new rules, man, you don't know nothing in that 1 hour, 8 hour period other than something broke. So that's challenging, I think.
No doubt. So transitioning just a bit, right? So we've had some overarching regulations. We've had some agency-specific regulations, right? We're all working our way through it and figuring it out. What's missing, right? What's still missing? Like we're going to need to address, because I just don't feel like it's done yet. I just don't feel like it's ready to get served up. So in your analysis, what's sort of missing? Like, here's some pieces we still need to get figured out.
Yeah. So again, it's really hard, I think, and we're seeing this, and we haven't even talked about it, and I don't want to talk about it. We'll talk about it later. Artificial intelligence. But we're seeing this in such a hodgepodge, right? It'd be really nice if there was, some sort of congruent policy, congruent understanding. You brought up DHS. DHS is foundational. Their safeguarding requirement is foundational based on this SB 800-171. But they don't necessarily directly apply SB 800-171. I think, yeah, and it's so you have defense contractors saying we're going to do this, but if you're a defense contractor and you're also supporting ICE or FEMA, then maybe that might not be enough, or it might be enough, or it might be overkill. So I think there's going to be a lot of there still has to be a lot of gelling. First and foremost. And I also think that one of the things that is going to crush a lot of people and the DoD proper is, I think we really need to come to a head on what is CUI. Because I think since it was released in 2010, what is CUI has been so bastardized over the past, and here we 14 years, that it makes it challenging for contractors to understand what it is they have to do. It's being used as a generalized term. It's not a generalized term. There are hundreds of categories of information that are CUI. Each of those categories is supposed to be governed by a particular law or regulation. And the government seems to just being, throw it all, it's all CUI. Yeah, but that's not how it works. I think one of the things that I've noticed is the Department of Energy, recognizes this in their recent update to the Headquarters Facility Master Security Plan in their Chapter 13, where they address CUI. They actually say, hey, CUI is, what is governed by law or regulation. However, the DOE also has requirements to protect unclassified controlled nuclear information. And they specifically call out, we don't want this to be addressed under the CUI. This has to be addressed under 10 Part CFR 1017. So, at least the Department of Energy is like saying, hey, listen, we understand that not all CUI is built the same. And I think that's something that the government needs to do, writ large, and especially the DoD.
And it's fascinating, and certainly the work that we do. We still have clients that are like, what CUI do I have, and how would I know it? Right? If you go up a notch and you say classified, it, right? The document's marked at the top of the bottom. It's all encrypted. The fire alarms go off when it comes through the email, and so everybody knows it. Right. And so a lot of people are like, it's not marked. I'm not really sure what's in or out of this category. And so I think both industry and government really seem to still be struggling with what is it? How do I know it when I have it? Sort of items. So I think
what kind do I have?
And what kind do I have? And then what do I need to do about it? So certainly I think all great stuff. So
yeah, and you're right. Marking. That's a big piece. Let's start there. Let's just start right there. Marking.
Right. If you didn't mark classified material, you'd be you're in the facility security officer's, office explaining, what are you doing? But in CUI, people are like, I'm not even sure I have it. And why would I have marked it? And the guy who sent it to me didn't mark it. And so there's no doubt some stuff there.
Or alternatively, we've seen it in signature blocks.
Yeah.
Like, hey, let's
today's date is CUI. Yeah, right.
Let's talk next Thursday. This is CUI. Well, no, it's not.
Yeah, right. No doubt.
That's an email, Chuck. That's not CUI.
Yeah, right. So where is this going, right? Where we look out, the government doesn't move at, commercial speed in terms of rules and regulations, right? They kind of move it at a much slower pace and just getting everything done. So 3 to 5 years, kind of what are some things, what are some trends we think are going to be happening? What are some things we think are like, this is highly likely this is going to happen?
Yeah, I think obviously it's not going away, right? I think industry needs to realize that they are, and this is the military in me, your collateral damage in a war, right? So your companies are in a position to be attacked. So cybersecurity isn't going to go away. The government is going to insist that you protect, at the very least, protect its data. If you don't want to protect your IP and your trade secrets, fine, really a bad idea. But the government says, if we're giving you data and if you're doing work for us, you're going to have to protect it. So, I do think that CMMC, we always talk about it from the DoD side. I fully suspect that there's going to be additional adoption. We're already seeing it with GSA. GSA is already indicating that they're going to adopt elements of CMMC for many of their contracts. But I suspect if you have a good program, you're going to see it spread out, right? I mean, FedRAMP is a great example of that. You can talk about FedRAMP's highs and lows, but for the most part, FedRAMP does work for the federal government. So I suspect CMMC will be in that same position, that there will be a similar regimen or regime for civilian agencies. I think the DoD will, obviously within the next 18 months have CMMC active and involved level 1 through 3. And we'll see that evolve. We'll see it might be messy at first, but it will eventually get into a position where people understand what they have to do. I think when they do that, we'll probably start seeing, for the defense contractors, I suspect you might not see a requirement for 7-19 and 7-20 and the SPRS scores. I think that's sort of a stopgap measure for CMMC. It's important to have it now, whether you're a domestic or foreign company. If you want a contract or subcontract with the Department of Defense, have your SPRS scores loaded and updated within 3 years. But I think once CMMC gets rolling, I could see that being eliminated or removed or basically overlooked. So I think that in 3 to 5 years, I think we'll see CMMC definitely meeting its obligation, meeting its requirements. And then we'll probably start seeing something similar in civilian agencies. It won't be the same, but it'll be some sort of at least level, CMMC level 1. I could see that being very important to them. So, and level 2 actually.
So one of the things that I hadn't seen so far, right? If you move to the financial services world, they're about resiliency and can you get back up and running and not lose a transaction, right? Because every transaction has 2 parties and who bought and who sold or whatever. I guess I was a little surprised, or I'm wondering your thoughts in the future of, listen, it's going to happen, and how do you get back up and running and preserve the data and if you lost it, where did it go? So we can go down that path. You and I both came from the Intel world where, listen, accidents happen, but we got to figure out how big the problem is. So I was a little surprised to see that. Any thoughts on the resiliency, the recovery phase? It didn't seem like that was as well or as thoroughly addressed as some other thoughts. Any thoughts on that?
Yeah, Matt, I do. It's right now the government. If you're a government agency, you have the obligation to protect the confidentiality, integrity, and availability of data within your network. It's of your data. And as a defense contractor, and I'm just going to focus on defense contractors, but they have you have 7012 in your contracts. You are also required to meet adequate security, and everybody focuses on 800-171 for that. But if you look at 800-171, 871 is specifically called safeguarding information, right, or safeguarding CUI. And the reason it does that is because while it touches upon elements of data integrity and maintaining the integrity of the data, it is focused on protecting the data. It's the confidentiality side. It has very little to do about data integrity and data availability. which are huge, right? I mean, most of the attacks that we're seeing now are affecting not the confidentiality of data, but rather the integrity of the data or the availability of data. And in some of our discussions with industry and threat acting leaders, right, people that are trying to figure out what's the next state of attack, we jest that one of the greatest attacks in the world would be, what if they got into your data and removed all your commas, right? That would be epic. And it doesn't, right? Okay, yeah, there's a confidentiality issue there, but there's a data integrity issue. Or what if they removed all the vowels of your stuff? That it's still available, but it's no longer integral, and nor can you trust the data that you what's of course corrected. So yeah, I find that fascinating, and I think it's interesting that things like data backups are only now kind of being formally regulated, where like these best practices. But I've told people for years that if you follow this SP 800-171 myopically, that's the only place you're focused on, you're still going to be 100% susceptible to ransomware. You're still going to be 100% acceptable to DDoS. So it is something that I think the government needs to focus on. Maybe NIST needs to start focusing on as well. Maybe in Reps 4 of 800-171, maybe kind of open the door a little bit, talk a little bit more about integrity and a little bit more about availability and continuity of operation.
Right. Well, listen, Alex, thank you so much for your time and for your insights today. Sounds to me like we got another date on AI and what does that mean for our government regulation. So I look forward to maybe another podcast on that particular subject, because we didn't even get a chance to talk to it today. But listen, I appreciate it. Thank you so much for your insight.
Thank you all very much.
Thank you for listening to Protiviti Legal Perspectives. If you'd like to listen to other Legal Perspectives podcasts, please visit our website at protiviti.com/legal-consulting.